This afternoon, and our Administrator of Elections, Jeff Roberts. Thank you for being here. The first item on today's agenda is the approval of our minutes from the meeting, our meeting on August 27. Commissioners, those are in your packet. Do you need a moment to review those minutes?
I'd like to make a motion to accept the minutes.
Thank you, Commissioner Starling. We have a motion. Do we have a second?
I'll second.
Thank you, Commissioner Neal. Any discussion? Hearing none, all in favor of approving the minutes from August 27, please say aye.
Aye.
Aye. Opposed? Thank you very much. Today's agenda pertains, we have two items pertaining to two charter amendment referendums. The referendum based on the For Good Government petition and the referendum based on the Metro Council substitute resolution RS 2020-480. Let's turn first for discussion and action on the charter amendment referendum based on the For Good Government petition. And with that, I would first like to call on our Administrator of Elections, Jeff Roberts, to give the Commission the procedural background on the petition. Please, sir.
Yes, ma'am. Included in your packet is the certifications that we provided to the clerk concerning the petitions themselves. Our initial look through the petitions discovered that we had 7 different formats for the petition. One of those formats had different language than the other 6. So those petitions we set aside and only verified the signatures on the petitions that had the referendum stated in exactly the same language. So those different formats were sent to the clerk. The clerk responded back with the letter that you see in your packet and put us in the position of where we are today.
Thank you. Thank you, Mr. Roberts. Are there any questions of our AOE from the commissioners? All right, thank you. Now we'll proceed to our discussion and determination of whether to hold a referendum election on the petition's charter amendment from consistent with our responsibility in the Metro Charter and with state law. Just as a side note, of course, the Commission's responsibility, and we're all fully aware of this, is not to be here to determine whether amendments are good or bad policy or debate our personal feelings on the amendment or the merits of the position. Metro Legal has provided legal information to the Commission in the course of this process. Metro's Law Director, Bob Cooper, will review with the Commission what our options are regarding the For Good Government petition. Mr. Cooper, the floor is yours.
Thank you, Madam Chair. The Chair has asked me to review the Commission's options with regard to the For Good Government's petition charter amendment that has been submitted. First, a few words about the scope of the Commission's authority. The Commission's role here is not purely ministerial. The Commission has the authority to review the legal sufficiency of a referendum petition. In 2004, the Tennessee Supreme Court held that a county election commission has limited discretion. The court said that the Commission can consider the form of a referendum petition and suggested it could review the petition's facial or procedural legality. This holding was affirmed in 2017 when the Tennessee Supreme Court said that election commissions, quote, are not strictly ministerial bodies, close quote, and that, quote, the election code clearly gives county election commissions the authority to perform functions that are discretionary in addition to their ministerial duties. Now, within this scope, the Commission has 3 options with respect to the petition in front of you. First, the Commission could decide to accept the petition and place the referendum on the ballot. This would not be an endorsement of the amendment. It would be a decision that the Commission does not have authority to consider any defects in the amendment, or that the Commission does not consider any defects sufficiently serious to prevent the referendum from proceeding. Second, the Commission could decide to reject the petition and decline to hold a referendum on the amendment. This would be a decision that the amendment is disqualified from the ballot by one or more defects in form or by facial or procedural illegalities. Third, the Commission could file a lawsuit in Davidson County Chancery Court seeking a declaratory judgment on whether the amendment should be placed on the ballot or should be rejected. The 1949 Tennessee Supreme Court opinion in Cummings versus Beeler provides a template for this third option. That lawsuit was brought by the Tennessee Secretary of State, asking the court whether it could hold a statewide referendum election where the constitutionality of the referendum was in question. Similar to Cummings, a declaratory judgment lawsuit by the Commission here would assert that the Commission has a significant interest in executing its legal duty to hold a special election. The lawsuit could also assert that the Commission is seeking an authoritative court ruling on potential defects in the petition before incurring the significant and possibly unnecessary expense of holding a special election. The lawsuit would name Metro officials and the four good government petitioners as defendants. Those parties would then litigate over the legal sufficiency of the petition. If the Commission chooses this third option, I would stress the need to expedite the proceedings toward a swift resolution. Those are the three options before the Commission. I'm happy to answer any questions.
Thank you, Director Cooper. Any questions for Metro Legal? Hearing none, then, Commissioners, we will move forward with our discussion of the petition and amendment. I do want to pose a question of you all here and see if we might have a consensus. We have 5 individuals signed up to speak. I assume it's all regarding this matter. If not, I'll trust you folks who signed up to let me know. In the past, we have taken public comments prior to our discussion and prior to any decision. Is there any agreement that that procedure has served us well and might do so again today?
I'm in agreement on that, Ms. Chair.
Thank you. Anyone else? Any thoughts? Commissioner Neal?
I am as well.
I agree.
Commissioner Delantis? Commissioner Starling?
I agree.
Thank you very much. Thank you very much. With that, then, we will proceed to public comment. And the first individual who has signed up for today is Ms. Lindsay Smith. Lindsay, do you want to, you can come to the podium there.
What would with the photo ID law?
Yes. Ms. Smith, are your questions mostly procedural with regard to the voting process?
Yes.
Today? Okay.
Yes.
Then I'm going to have our Administrator of Elections address those for you.
Okay, thank you.
So first-time voters voting on the machine, we're going to be providing a instructional pamphlet, 1 page, that shows you how to vote touchless using our equipment. You will also receive instruction, the voter will, when they come into the precinct. So for both early and election day voting, we will educate the voter through the voting process. There will be a machine operator at each of the ballot marking devices to assist the voter should they have any questions.
Specifically for absentee voters, first-time voters, so now they can vote absentee. How will you make sure that a first-time voter that's also voting absentee is in compliance with the photo ID law?
We're asking those voters, when they make a request to our department, if they haven't already sent us a copy of their driver's license or passport, those kind of things, with their request, we will reach back out to them to make sure we've got them squared away so that we can send them a ballot.
Okay, and then specifically, Judge Richardson's ruling, it says that first-time voters can receive an absentee ballot if they request one. And if they've already requested it, already returned it, and it already says on the Davidson County Election Commission website that it has been received, and now we have this photo ID issue, will their ballots be counted? And also, will voters have to prove who they say they are if they haven't already?
For any of those voters that fall into that category, we'll reach back out to them. I think at the point of Judge Richardson's ruling, we had 9 voters out of the 21,000 people that had requested an absentee ballot that fit that category. So we're not talking a large group.
Okay. The Tennessee Secretary of State website, I promise it's my last one, it says that you may still need to provide identification. So for clarification for all of the voters, will they or will they not have to if they've already voted absentee?
If they've already voted an absentee ballot, we will reach out to them to make sure they are in good standing as part of our process to count the ballot. But we will do that ahead of time. Our goal is to get that voter squared away well before Election Day. So there's no question their vote will count.
Okay, well, that was all that I had. Thank you so much for all that you do.
Thank you for being here. Next on our list for public comment is Mr. Rick Williams.
I'll refer my time, ma'am, to Jim Roberts, who needs to speak.
All right, thank you. I think I saw Mr. Roberts come in. There you are. Thank you. Thank you. You are welcome. I know you and our AOE spoke earlier this week, I believe, so you are welcome to comment. Thank you for being here.
And I'll try to make this quick. I thank you for the opportunity to speak to everyone today. And I'll make this very brief. This is about my 5th or 6th time dealing with the Election Commission over the years as an attorney. And I've been involved in multiple ballot initiatives and unfortunately, regrettably, litigation over several. It is my belief that we turned in over 20,000 signatures of Davidson County residents, voters. We've collected almost 27,000 signatures. They're still coming in. In fact, I opened up another 67 just today from people who sort of didn't get the memo that they'd already been turned in. The people of Davidson County want this on the ballot. There's no middle ground. I believe the statute, Section 19 of the Charter is very clear that all the duties from this point forward are ministerial. And I have the utmost confidence that this board will put this on the ballot as written. I would like to address one issue or 2 issues that I've heard rumor about. I've heard rumor that there's been some suggestion that this ballot initiative should be broken up into multiple parts. That was an issue that arose in 2008 when I assisted Eric Crafton with his ballot initiative. You may know Mr. Crafton came up with a ballot initiative, gathered signatures, and there was some litigation over that. I did not know Mr. Crafton. I did not become involved until after the Election Commission had acted. But there was discussion then. Ms. Patricia Heim was, I think, the chairman at that time, or at least a member. And it was decided at that time that this body didn't have the authority to change what the people have asked for. Let me be very clear to the commission that the language used on this ballot initiative was crafted over about a 10-year period. And every word was chosen intentionally. It says amendment, not amendments, for a reason, and it was absolutely intentional. And it is our expectation, and I'm speaking on behalf of those 27,000 voters who signed these petitions, that it be placed on the ballot as written. It was done that way intentionally. It was not by accident. Second, it is my sincere hope that there will not be even a consideration of denying the people of this county their right to vote on this petition. The fact that we gathered those signatures and turned in those signatures so quickly is not indicative of whether it'll pass or not. I have no idea whether it'll pass or not. I've met at least 2 people so far who are against it. I bet there's at least 1 or 2 in this room, and we might even get up to 10. But it's not a done deal. It's an opportunity for the people of this community to express their desires at the ballot boxes they are entitled to do. And the refusal to allow them to express their rights in voting is a civil rights violation. There has been litigation in other states. There has been situations where commissions have honestly gotten into trouble for not letting people have their day at the ballot box. Tennessee law is crystal clear. There's a case called the City of Memphis versus Shelby County where a very similar situation arose, where the City of Memphis did its own ballot initiative and the county decided it was unconstitutional. The county exercised a judicial function and decided that they knew better than what the city wanted, and that was struck down quickly by the Court of Appeals. Today is not your time to decide if the people of Davidson County have made a good decision or a bad decision. It is not the time to decide whether this ballot initiative is constitutional or unconstitutional or wise or stupid. Today is the time for this commission to fulfill its ministerial duties that are prescribed to it under Section 19 of our Metropolitan Charter. That charter is the constitution of our government. It represents the restrictions and limitations placed on the metropolitan government. It is not a suggestion. It is not an idea. It is the city's constitution, and it has outlined the procedures by which I had to fulfill and which the 27,000 people who signed these petitions had to fulfill. Section 1 of that Article 19 talks about how the council and how the people amend their charter. And sections 2 and 3 talk about what your job is and what the metropolitan clerk's job is. And it doesn't give you any discretion to change what the people of the council have asked for. And I ask you, I'm begging you, please do your ministerial duty. Do not do anything that violates the law. Please. I'm just asking you. I've been down this road before. I don't want to go down this road again, but we all will go down this road. I promise you. If anything other than this ballot initiative is placed on the ballot as written, the only discretion that this board has is to put the little blurb at the top. And I hope that you will do so honestly in a way that reflects what this ballot initiative is designed to do, and that there won't be any shenanigans. That's never happened in this state. It's never happened in this city, but it has happened in other states and cities. And I've seen that litigation as well, and I have no desire to be a part of that. This time to let the people make a decision whether this was a good idea or not. I'd like to address one last thing. I know I don't have much time, and I don't want to take much of your time. Is that last week, and I hate to say this, but last week I wrote a letter to Mr. Roberts, I should know that name, Mr. Roberts, because I was concerned that I had been told by a Tennessean reporter that this commission was going to meet privately with its attorneys at Metro Legal. I believe that that action was outside of the Open Meetings Act. I know that it is permissible for a board or commission to meet with their attorneys, but it is standard procedure for that meeting to be publicly noticed, and that meeting held, and that committee adjourned to a private meeting, which is totally appropriate, and then come back and discuss the advice they've been given with the public in the public's way. That is how that's been done traditionally. I think that is how it's done legally. I received in response to that letter, I copied Bob Cooper, the director of the Metropolitan Department of Law, on that letter, and I have a copy of his letter here today. He wrote me back and said, well, we had to meet in secret because I, Jim Roberts, had threatened a litigation in this case against the commission. And I want it to be very clear to you folks and the people in this audience that I was called up by a reporter from the Tennessean last Thursday afternoon and told that a secret meeting was already planned for the next day. And whether I was quoted accurately or not by the Tennessean doesn't matter. What matters is that the Department of Law Director, Mr. Bob Cooper, wrote me a letter that was a lie. I'm not going to say it nicely. It was a lie. And he tried to use a Tennessean reporter's story as a justification for an improper meeting. I hope that you will not do that. I hope that if that was done, it was done in error and by accident. The people's business is serious. I sued Metro in June of this year and won an open meetings case on the same thing for not following procedure. I don't like doing that, but I will. I have been called anti-government by Metro's lawyers. I'm not. I am pro-people and anti-stupidity and anti-corruption. And unfortunately, that has led me to be in litigation against the metropolitan government more times than I would like. This is a simple ballot initiative. There's more coming. but this one needs to be put on the ballot as written. And I ask you today, on behalf of those 27,000 people who took the time to sign this petition and mail it back to my office, that you follow the law. You place it on the ballot without question. You don't have to like it. You don't have to want it. But I submit to you that your ministerial duties command that you do it. And let's just do it. And on December 5th, we'll have us a knockdown drag out at the election day, and we'll see whose idea is better and whose idea is worse. So I appreciate it. I appreciate your hard work. I appreciate the fact that I have not had to sue the Election Commission in, gosh, over a decade. I appreciate that. It's not what I want to do. And so I thank you all for the time to speak, and I look forward to you doing your duty. Thank you.
Thank you, Mr. Roberts. Our next individual who has signed up is Kenny Ames. Good afternoon, Mr. Ames.
Good afternoon. Well, first, I didn't know I was going to be speaking. Someone asked if I was signed up to speak, and I was like, no, I wasn't, but I would like to be heard. So I'm unprepared. I did jot a few things down. I'm a musician, and all of my work was headlining cruise ships, and that got poo-pooed all this year. And so my wife and I ended up helping work some of the tents to get the signatures. And it was truly heartbreaking to hear some of these stories of people on disabilities, fixed income, and people like myself and my wife who, you know, we're getting by, but my gosh, a 34% tax increase that hits hard, and that hits at home, and that hits when we're unemployed. And it was just heartbreaking time after time. Small businesses with their homes attached to their businesses that are losing everything. Women crying. I mean, just, you know, God dang, how can this be right? How can this be legal? You know, isn't there some other way? God darn it, you know, stop giving away the fairgrounds, you know? It's how do some of these people sleep at night, truly? You guys need Jesus. You know, and from what I understand, there's been many options to balance the budget. You know, and some of the benefits for the council members, that situation, you know, or, you know, raises and, you know, come on, man. I've lived here 24 years, and this city has been on fire. You know, the last 5 years, the growth, the industry, you know, and we don't have a surplus. No, we're not even broke. We're in debt, what, $4 billion, was it? $3.6 billion, I know, as of January of 19. But how the hell can that be? And why do we have to pay for the sins of our predecessors or the sins of the people that can't keep their legs together in this? Sons of... Sorry,
Mr. Ames.
I'm sorry, I understand. My apologies. It's passionate. I'm passionate about this. And the 27,000 or 26,000 or whatever the number was, you would be surprised. Not every you know, Republican, Democrat, it didn't matter. People were running to the tents with pens. Where do I sign? You know? I don't know. I didn't plan on speaking here, and I'm sorry if I said some things. Maybe I'm just passionate, and it's frustrating. And I just see the city I have grown to love over the last 24 years just being held hostage. I just see a lot of things that inside here just hurts, you know, and I don't know what to do about that. So my wife and I, you know, other than voting in all the standard elections, have never reached out to do anything. And we did for this. And many people felt the same way. And it's just, I don't know. There's got to be a better way. And I mean, I don't know. I think that's about all I got. But I appreciate you letting me have a voice and letting me speak my piece.
Thank you.
That means a lot. Thank you.
Mr. James Garrett.
Good afternoon to the commissioners. I was going to defer my time, quite truthfully, until I heard the various comments here, and a thought came to my mind. And first off, I'd like to thank each of you for letting us, the public, have the opportunity to speak to you prior to your deliberation on the question at hand. Typically, we speak after you've done that, and typically I get up and I thank you for all the work you do and sit down. You know, it's that way. But I was thinking, several weeks ago, sometime in the recent past, I've heard a comment, heard a rumor, heard somebody say that the councilman, our council, the Metro Council, is considering an action. And with respect to my councilman, Jeff Syracuse, to Councilman at Large Mendez, who I see is here visiting us, and to the other members of the council, that rumor focused around changing the charter. I think it's section 19, I'm not real positive, but changing the charter to eliminate the petition drives that we're going through today. Guys, my thought with that, you know, this nation is founded on we the people. We the public have got to have a mechanism in which we can redress government. Government is there at our pleasure, not at their pleasure. And we have got to have a mechanism where we can redress government. Petitions such as this are those measures that we employ. Not saying pro or con for the referendum. The fact that the public has spoken speaks volumes to me, and it should speak volumes to you, because that is our method of redressing this government. I think the 34% tax increase is more than I can afford. It's something that I really am not pleasant about paying if it goes through and if it passes or if whatever it does. But I appreciate the fact that we, the public, have got a mechanism to redress this government. And I thank you for your consideration.
Thank you, Mr. Garrett. And I will apologize in advance if I mispronounce Michelle Toddy. Thank you, Ms. Toddy.
First, I want to say I'm scared to death, but I'm speaking for myself and probably thousands of other people that are out there in my position. I've had a business in Nashville for 17 years. I've been in Nashville for 32 years. My business has been devastated. And then not only with this COVID, we had a tornado. It took out my husband's job of 40 years. So here are two people that have worked all their lives. One without a job after 40 years, no insurance. And we live in the General Services District, so we're talking 37%. And I'm not just speaking for me, I'm speaking, there are thousands. I worked those tents as well. There was so much anger. They couldn't get out of the car fast enough with their pens to ask. Our voice has been taken away, and that's why we're out there. Government is supposed to be about the people, and it's not anymore. A few shouldn't have a say over many. And so I feel like I'm not just doing this for me, I'm doing it for so many, just like that musician said, they've been devastated as well. We need to get the power back to the people and let them speak. Just because you don't like it or you don't think it's right doesn't give you the reason for us to not have a voice. And that's why I'm speaking today. Thank you very much. I appreciate for you to listen to me. Thank you.
Thank you for taking the time to be here and for your courage in addressing us. Thank you. That concludes our public comment. And Oh, Mr. Mendez, I'm sorry. We will turn next to your charter amendment unless you prefer to speak now?
Well, thank you very much, Chair. I had prepared comments for both. I didn't understand that they were going to be taken separately, so I do have comments about this one.
Okay, then proceed.
All right. Thank you. I do, like you, appreciate everybody coming to speak here today. Just quick background, and then I'll get to the substance. We had municipal elections last summer. We voted on a 16% tax rate increase a couple months before the election last summer, and every council member who voted for the rate increase got reelected except for one. Of the 4 council members that voted against the rate increase, 3 of them lost. Almost all the district council members ran last summer on the idea of pushing a rate increase. And I just want to make sure that to the extent we get into whether the people want it or not, it's been clear it passed 32-8 in the council. But on to the substance. I don't know all the legalities because I haven't read all the case law, but to the extent you all have discretion to hold this off the ballot, I urge you to do so. And I'm going to just give you a couple of the form-related reasons that will make governing extremely difficult based on the form of this charter amendment. Traditionally, charter amendments look like legal documents, not Facebook rants like this one does. This is unnumbered. It does not delete sections they don't like. They just add new sections. So if this passes, we'll have one section, 6.07, laying out that the council has complete discretion to set the tax rate. And then we'll have another section, unnumbered, stuck in wherever we're going to stick in an unnumbered section that says something totally different. There will be an active conflict between sections in the charter. On real estate, currently the charter gives complete control to the mayor and the council on disposing of real estate and interests of real estate. Those sections will remain if this petition passes, and instead we'll get an unnumbered section stuck in somewhere else that contradicts the existing sections of the charter. Similarly, on when to have a bond referendum and how to handle bond issuance, there's a complex, long, single-spaced, goes on for quite a while procedure for how bonds get issued by this municipal government. And instead of deleting any of that, amending any of that, changing that, we're going to add an unnumbered section somewhere that flatly contradicts it. And speaking for somebody who is trying to operate this government, having the charter have multiple internal contradictions is a form that is untenable. Secondly, we'd have to know that it does fundamentally change the way government will work. We will move to a California-style governance by referendum. We'll have referendums over Rose Park leases to MNPS, Fordyce Center, 12 referendums over tax rates over the last several years. The Customs House and North Nashville Transit Center, telecommunications tower leases, every capital spending plan. The form that this injects by creating this, attempting to create government by referendum while leaving completely contradictory sections in the charter is not something from a form point of view that ought to be acceptable. I will, if you want, talk about the council passed item now, or I can come back. But I wanted to talk about those specific things for the petition referendum item.
Why don't we come back if you don't mind?
All right. Thank you very much.
Thank you very much. Thank you. Commissioners, I believe that does now conclude our public comment session, and thank you for letting us take that at the beginning here. And the floor is now open for our discussion. Commissioner Hirschfeld.
Thank you so much, Ms. Chairman. First off, I want to thank everyone from the public who came to speak today. I know that this is a very emotional issue when you're talking about taxes and the hardship that so many Nashvillians have been through, specifically in the past year, even longer for some. Unfortunately, it looks like we're going to be in this for a while, and I appreciate your courage for coming to speak and to making sure that your voices are heard. From a commission perspective, I do have some concerns about the form of the actual petition that has been put before us. Specifically, I have some concerns about the lack of particular topic areas and where things would be inserted within the charter, in addition to the bond issue. My understanding from our attorneys and some other research that I've done, that there is a very complicated legislative process that the state has gone through on how it is that bonds are issued and referendums are done on that. Do we have any more information perhaps from our counsel about how it is that those bond referendums typically are done by the state statute?
Director Cooper?
Certainly happy to do that. And the controlling state statute in this regard is the Local Government Public Obligations Act of 1986, which prevails over any other conflicting law. And it sets out a very detailed process for the issuance of general obligation and revenue bonds, which involves the local governing body issuing a initial resolution or adopting an initial resolution to issue the bonds, then publication of notice of that resolution, and then a time period within which anyone wanting a referendum on that would circulate and file a petition signed by at least 10% of registered voters who would be taxed for the bonds, which in Metro Nashville is almost always the entire county. The state act does not allow referendums if the bonds are to be issued for waterworks or sewage pod projects, or if the local governing body determines that an emergency requires the bond issuance.
And thank you, Director Cooper. And so my understanding then is that that state statute and that state process would control over what it is we would do here as a city or what's proposed here within this referendum. Is that correct?
Yes, that is correct.
Okay, thank you. That's all the comments I have for the moment.
Others, commissioners? Commissioner Neal.
I did have another question for Mr. Cooper as it relates to the limited question that's before us. We appreciate the participation of as many people as possible in the public comment period. We appreciate the time and effort that went into preparing for those, and we appreciate more participation, the better. With regard to the business at hand today, I was hoping that Mr. Cooper could outline a little bit the distinction between a deficiency as to form and a deficiency as to substance, and how the difference between those could impact our ability to act or not to act. Before you weigh in on that, I also want to thank you for your fine counsel throughout this process. I've been fortunate to work with a number of public servants, and you have served us well, and the city and the state, and so I appreciate all you've done and continue to do. So thank you.
Thank you, Commissioner Neal. Let me briefly respond to your question. There is the courts in Tennessee have indicated that it would be appropriate for a election commission to deal with issues of form of a petition, and in addition have suggested that the commission could also consider elements that involve facial invalidity. The court has said that that commissions that going into issues of substantive constitutional validity would be beyond the scope of what an election commission should do, that should be left to the courts. The opinions have not drawn a clear distinction between facial validity and substantive validity, but I think that looking at the law in general, certainly with regard to form, that would involve not just the manner in which the amendment is drafted, as well as the form of the petition, the number of signatures of the petition, but also whether or not the petition involves a subject matter that is open to the petition process. So to use the example that Commissioner Hertzfeld mentioned, is it appropriate to have a referendum petition involving issuance of bonds that might be in conflict with the process for petitions related to bonds set out clearly in state law? Also, the facial invalidity, I think what courts generally refer to when they are talking about the facial validity of a statute, or in this case perhaps an amendment, is whether there is any circumstance under which the language in the provision in question could be enforceable, or is it unenforceable in all circumstances. So I think that would be one rule of thumb that the Commission might use in evaluating whether the provisions before it are facially valid.
Thank you, Mr. Cooper. Very helpful as always.
Commissioner Hertzfeld, and then Commissioner Starling.
Thank you. Of course, I'm going to have a lot of questions. I always do. Mr. Roberts, I appreciate the fact that you spoke to the severability issue of the petition that's been put forward. And for those following along at home, that is really the question of if each of the 5 questions and checkmarked boxes and statements within the petition could be somehow separated. So if there's a concern perhaps with the bond issue, but not necessarily with the tax issue, could those be split up and have some put on the ballot for everyone to vote on, or does it have to be all or nothing? And so I appreciate you letting us know the intent on that. I do think it would be kind of difficult to figure out which voters were voting for perhaps the open records portion of it versus the tax portion of it, or if everyone was voting for all of that. General Cooper, if you could let us know a little bit about the severability clause issues within the law and whether or not we would even be permitted to parse out and kind of pick and choose. And I know that I see Mr. Roberts shaking his head that in the past that has definitely not been allowed by the Commission, but if there's any also state law that would buttress that point, I would be appreciative to know it. There was not a severability clause specifically within the petition. So sometimes what you'll see in a law or in a petition is someone will say, hey, if one part of this is not okay, let's go ahead and vote on the others. And that was not included within this particular petition. I see Commissioner Delanis.
In my own personal research, I came across 10 Code Ann 13110, which is in the very beginning of the code, and it talks about construction of statutes, and it is entitled Severability of Code. And I believe it sets up really a situation where severability is favored rather than disfavored. And I've got a copy. I've got some copies of that if the other commissioners would want to see it. I also found a case, and it's called Williford v. Klepper, which is a February case from the Tennessee Supreme Court of this year, and the decision was written by Chief Justice Bivens. And let me just quote from it. It says that the legislature's endorsement of elision, and that's severability for the audience. It's basically the two words mean the same thing. Justice Bivens is talking about the statute I've just handed to you. It says the legislature's endorsement of elision does not automatically make it applicable to every situation. However, when a conclusion can be reached that the legislature would have enacted the act in question with the unconstitutional position omitted, then a lesion of the unconstitutional portion is appropriate. And this case doesn't seem to talk so much about intent as it relies upon that statute. So that's my comment on that. I have some more comment later, but I do believe that perhaps this commission has a bit more authority than perhaps we thought based on that statute in this new case that's just in February of this year. And I have one copy of the case, unfortunately, but if you'd like to read it, I've got it right here.
I would really appreciate it if we could pass it down. Thank you.
So we'll hold Mr. Delantis' other comments, come back to Director Cooper for any response to Commissioner Hersfeld's question.
Certainly. The courts have held fairly uniformly in Tennessee that the doctrine of elision, that is, applying severability to legislation, is disfavored in Tennessee. There are no cases that we are aware of where the doctrine of elision has been discussed in the context of a referendum. But if you look at the court cases dealing with legislation, then the court has said that while elision may be done, there needs to be some evidence on the face of the legislation in question that the legislature would have enacted the act being challenged in a severed form had that been presented to them. And so the court said to act without such a finding would engage the courts in judicial legislating and taking over the legislative role that is reserved to the independent branch of government. And a number of courts that have dealt with the issue of severability in the referendum context have stressed the difficulty of determining what multiple signers of a petition would have done if presented with a different petition. So that is the case law that we are aware of with regard to this issue.
Commissioner Hersfeld, do you have other questions?
That's all for now. I'm sure I'll have more, but I'm good for now. Thank you.
We'll be here. Thank you. Commissioner Starling.
First of all, I want to thank everyone that spoke and voiced their concerns on this matter. It's always important that the citizens of Davidson County have a voice, and I really appreciate you all coming and speaking before us. I'm somewhat concerned, and this may be a question for Mr. Cooper. The language of the petition itself, it seems as if it's being more politicized than any amendment that I've seen before. And I'm somewhat concerned that if this language were to get on the ballot, does it allow other petitioners to come with similar language? I'm seeing the giveaway of the parks, the out-of-control spending. That seems a little politicizing on things that we tried to make sure from the Election Commission that we don't do. And I'm just concerned, and I'd like to ask Mr. Cooper, what is his concern with this?
We have reviewed petitions and proposed amendments that have been put on the ballot recently, let's say over the past 10 years or so. And the form of this is certainly quite different in style than those previous amendments, both amendments that were adopted and amendments that were not adopted in referendum. The use of political rhetoric will pose, I think, significant challenges to courts trying to interpret the legislation, as well as the very, more vague, general language and use of undefined terms. It would certainly not be a trend that we would hope to see continue, as opposed to an amendment where, as the councilman points out, to the extent it is attempting to change something in the charter, it makes specific reference to what is being changed, and where necessary, deletes conflicting language so that it does not leave to the courts a very difficult process of trying to reconcile two very different provisions in the same document as you would have in the charter.
Mr. Delanis, did you have other questions? Or
I don't have
comments?
any other questions, but I do have some things I'd like to say.
Please.
Okay. My name is Jim Delanis. I'm one of the commissioners. And first of all, I would like to thank the For Good Government people for presenting this petition. We are hearing a lot in our country about how people are trying to change things, and this is the right way to change things. So I want to thank you for going about this the right way. And you're going to hear me quibble and pick away at this referendum in certain small ways, but I don't want that to take away from the fact that we at the Commission appreciate when people bring things forth properly in the democratic process. And I think I speak for all the commissioners when I give you my gratitude, especially now. This does present some thorny legal issues, and the Commission at least believed there was threatened litigation coming, and I would like to compliment Mr. Cooper and Ms. Ecke and their office for the work they have done on this matter. You hear a lot of rumors about things supposedly happening or not happening, but the Metropolitan Legal Department's work with us has been cooperative, and they've been hardworking, and they have tried to advise us on the law, and I certainly appreciate their good work. This referendum does present thorny issues to this commission. I think the public probably only knows about the very first part of this referendum, which is the one that limits property tax increases to 2%. There are 4 other provisions. Each of them are major potential provisions on their own. Each would have major impact on the city. The 2 most major is one which would require a referendum, which typically costs close to $1 million every time the city purchases or sells land at a price of more than $5 million. Then there's another provision concerning the issuance of bonds, which would require a referendum anytime the county issues a bond in excess of $15 million. And bear in mind, and we all have budget issues, that costs about $1 million to have a referendum. So each of these have major impact, and the 5 different parts are written as one part. So that's something that this commission has to wrestle with. There are issues about its form, and I think each of the commissioners have raised those issues. But again, we have, I believe, at the commission, limited discretion to address those issues. And that is the reason why these are difficult issues for the commission. We can only address constitutional violations that are said to be facial. In other words, they're so clear that they're just obvious on their face. So we are limited in that regard. Now, there's been some discussion of the charter and what it is. The charter is kind of like the Articles of Incorporation of a corporation, but still the state constitution supersedes the charter. The state statutes supersede the charter. And typically, when we receive a proposed amendment to the charter that to go on a referendum, there's been carefully drafting to avoid conflicts between that amendment, that referendum, and the state constitution, and also the state statutes. And this particular set of amendments really, it does not look like it was appeared to have avoided those conflicts. So there are conflicts between, in some instances, between these 5 separate provisions and the state constitution and the Tennessee statutes. However, our discretion to address those is very, very limited. I think it's already been commented on that typically our functions are ministerial only, but there is a new case out that gives us quasi-judicial functions in certain areas. However, that case is not a case involving a referendum. So as I view it, we are still within an area of the law where our duties are primarily ministerial in nature, and we are not within a quasi-judicial function. I believe that consistent with the existing law and consistent with our ministerial function, we can delete the argumentative language and still be consistent with the intent of the 20,000 people that submitted this referendum. And I think that would be, we could liken the preamble, the first 2 paragraphs, to a preamble, which has a lot of argumentative language. And similarly, the headings in boldface on each of the 5 sections, which are argumentative. I believe that we do have the ability to delete those, and I suggest that we at least consider doing that. As some of the other commissioners have mentioned, there is an issue with item 3, the one that deals with bond issues. And in that one, as General Cooper indicated, there is a very, very, very detailed set of state statutes that tell cities how they can issue bonds, and there's also a very detailed provision that says how many signatures you need to put a referendum on the ballot that affects a state's ability, that affects a city's ability to issue a bond. And there aren't enough signatures on this petition to qualify anything to change Metro Nashville's ability to issue a bond. And our ministerial duties clearly relate to counting signatures on the ballot. In my opinion, and with all respect to Mr. Roberts, it's clear that these are 5 separate provisions. They were intended to be part of one amendment. Clearly, yes, that's true, but based on the recent case law that I found last night from the Tennessee Supreme Court and based on the Tennessee statute, we could sever out, in my opinion, the bond issue from the rest of them without doing violence to the intent of the 20,000 good Tennessee and Nashville citizens who want these other issues on the ballot. And I suggest that we can do that and still remain in our role, proper role as an election commission. As far as the other provisions, the issues with those are clearly issues that deserve public debate, and they are not so clearly violative of the law that we should address them under Tennessee law. We do not have the authority, and even courts don't have the authority to, on the front end, attack the constitutionality of a statute, and we should only do so as a last resort. And we are certainly not in that situation at this point. So I am, after listening to everybody's comments and with the good counsel that we've received, I am suggesting that we approve the 4 issues without the bond issue question, and that we put those 4 on the ballot, that we remove the argumentative language as I've described it, the first 2 paragraphs, which I would call a preamble to legislation, and remove the boldface headings because of their argumentative nature. And again, I'd like to thank the people that have brought this referendum because this is the right way to do it.
You're offering that as a suggestion for the commission's consideration?
A suggestion that I would hope would form into a motion, but I don't want to cut off debate because there may be other people that want to talk about it freely.
Commissioner Hertzfeld?
I told you I'd have more questions. Thank you for that very thoughtful analysis, Commissioner Delanis. I appreciate your perspective here a lot. And again, I mean, I also feel very strongly that when the public speaks and they want to be able to vote on something, we should let the public speak, right? That is the core underpinning of our democracy. However, as Commissioner Delanis has pointed out, we do have some responsibility here, even though our authority is somewhat limited, to make sure that what goes on the ballot is appropriate to be on the ballot, and works within the confines of our laws and the process and the procedures that, other folks have put forth before us, right? Whether it be the state legislature, the state constitution, the Metro Charter before us. So I had brought up the issue of the form issue on the issuance of bonds, but I do believe that there are some other form problems with some of the other sections within this particular referendum. Looking specifically at number 5, with records being open to the public, my personal opinion on the openness of government notwithstanding, I clearly believe government should be open, very open to the people. But the Open Records Act under Tennessee law is very specific about what is required and who it applies to and what damages and so forth are available for violations. Director Cooper, perhaps you could talk to us a bit about the differences between this petition's language as to open records versus the state law and how those two would conflict, perhaps? Not to put you terribly on the spot.
The challenges to interpreting the provision, the last provision of the 5, begin with it appears to extend the the Public Records Act to, quote, public instrumentalities under Title VII, close quote. There is no definition of what Title VII is. There is no Title VII in the Metro Charter. This doesn't refer to any other document. For purposes of analysis, we assume that this is referring to Title VII of the Tennessee Code. But public instrumentalities under Title VII are already subject to the Public Records Act, so it's not clear why that would be repeated here. The Public Records Act does allow for the recovery of attorney's fees, but only where there has been willful refusal to produce documents. There is nothing in the Public Records Act that awards treble damages, nor is there anything in the Public Records Act that would bar a public instrumentality from continuing to receive public funds. And so that is, those are two obvious conflicts with the provisions of the Public Records Act.
Thank you for that, Director Cooper. And I believe there's also been a significant amount of litigation that's talked about private entities operating as the functional equivalent of a government entity and therefore being subjected to the Public Records Act under some sort of analysis that's been developed throughout Tennessee law. Is that right?
Yes, there is a doctrine that would look to see whether a private entity is so entwined with government that it is the functional equivalent of a governmental entity, but that does not appear to be what this provision addresses. This provision is aimed toward entities that are already governmental. They are public instrumentalities under Title VII, and so there you're talking about sports authorities or health authorities or things of that sort. If you look at what is defined under Title VII does not deal with private entities that are the functional equivalent of governmental entities.
Okay, thank you for that, Director Cooper. Additionally, the professional sports team topic, the raising of the tax rates and the giveaway of the parks. There are various forum objections to each of those as well, according to your analysis. Is that correct?
Well, certainly, the one dealing with professional sports teams, particularly, raises issues both of retroactivity, impairment of contracts, both of which are explicitly unconstitutional under the Tennessee Constitution. And also raises issues of illegal, takings without due compensation by the government, since it contemplates that property interest held by the sports teams would revert without compensation. So I think you have all of those issues implicated with that provision.
Okay, thank you, Director Cooper.
Other discussion? Mr. Delanis, Commissioner Delanis?
Yes. I would just note that as to all of these 5 provisions, there's only one that goes clearly to our duties, to our ministerial duties, and that's the subject of the number of signatures on the bond provision. That's something that the courts have been clear about, and we should, especially on an issue of this public importance, we should not venture off into an area where the courts have not given us clear authority. And I believe we do have the clear authority when it comes to counting the signatures on this petition. We do have the clear authority to take that issue off the ballot, but it's the only one that we have the authority to do that. And I believe that under the statute and the case I've cited, we have that authority. But I respectfully suggest that we do not have the authority to just start striking parts of this referendum down, because it may or may not, there may or may not be some complex or unclear basis to challenge it under the state constitution or under the state statutes. So in my view, the only provision that we have the authority to take any action on would be the bond provision. And I believe I think just good sense tells us that we should not put argumentative language in something that's on the ballot. I don't think that would be offensive to any of our case law. But I do believe if we start going into, let's say, the Open Records Act, and if we start to make a determination of exactly how it might conflict with the language of the existing state statute, or exactly how this provision about sports teams, exactly how, based on some really sophisticated legal analysis, how it might conflict with the Tennessee Constitution or a Tennessee statute. I think we're getting off on some untrod grounds, and I suggest that we stay on solid grounds and just address the signatures on the ballot, signatures on the referendum.
Madam Chair, I did have one other response to Commissioner Hertzfeld's question. In terms of form, and which, as I indicated earlier, also goes to whether something is an appropriate subject matter for a referendum by petition. The case law and statutes are clear that a petition cannot be used by a county a referendum cannot be used by a county to set tax rates, property tax rates. And so that would be another aspect of the amendment here that does raise issues of form, and that it would be using a referendum process to set property tax rates where the statute clearly says that those rates are to be set by the legislative body of the county. I guess the other, otherwise, I would say that with regard to form, that also reflects, as some of the case law shows, that where a matter is so clearly illegal that it is not in dispute, that has been characterized as a defect in form. So that's a broader, obviously, approach than simply looking at the petitions or where something is a clearly laid out referendum process, as with the bonds. I hope that's helpful.
Thank you, Director Cooper.
Do we want to regroup on our three options, or what potentially sounds like? Mr. Garrett, I'm sorry. No, but I believe you may be out of order since we have had our public comments, sir. No, sir. No, sir. Thank you for understanding. So my question was, do we want to hear once again our three options? And it sounds as if we have the potential for a fourth option to be added to this mix for our consideration this afternoon. Director Cooper, would you, from where we roughly opened when you presented our three options, would you mind reiterating those for us again, as they may stir additional conversation and questions, please?
Certainly. In addition to what Commissioner Delantis has offered as a suggestion, the Commission could decide to accept the petition and place the referendum on the ballot. The Commission could decide to reject the petition and decline to hold a referendum on the amendment. The third option is that the Commission could seek guidance from the courts by filing a lawsuit in Davidson County Chancery Court seeking a declaratory judgment on whether the amendment should be placed on the ballot or rejected.
Thank you. And Jim, do you want to summarize yours? I know it's not in the form of a motion, but if, as a suggestion of summary may be appropriate.
Yes, my suggestion would be that we put 4 of the 5 provisions on the ballot, that we sever the bond provision, and that we delete the first 2 paragraphs at the top of the page. And just for the audience, those are not substantive provisions. Those are general explanations. They would be what I would call a preamble, which would not be part of legislation in any event. And then we take the headings in boldface that are in the beginning of each of them, so that we would essentially preserve all four of them, but we would sever the bond provision and let the four provisions in substance go forward.
Commissioner Neal.
I had one question for Mr. Delanis. I was curious, in your research, did you find any distinction in the application of the elision concept in the context of legislation passed by the legislature as compared to a referendum? What occurred to me was that there are some resources available to a court to determine which aspects of a piece of legislation were intended. When you're constructing, statutory construction, it's ordinary course to review the discussion, the comments, the votes, and it informs the language, and it could in fact inform the elision concept, whereas a referendum, there is not that available resource to us, and I thought that there could be perhaps a distinct analysis for that approach, but I have not researched that.
I did not find cases that specifically dealt with a referendum. The only case I've found in the statute I found dealt with statutory construction, and I would suggest in this case that there is textual evidence in the way this ballot provision is written, because each of the five has a separate checkoff next to it, indicating that at least to the petitioners, there was some separation between the two. Granted, it does say one amendment. There's no question that it says one amendment, but the five separate issues are separate subject matter. They do not really relate or depend on each other. And under the recent decision from the Tennessee Supreme Court, which is the Williford case, removing the bond provision would not in any way affect the force or strength of the other four provisions. And as I read that case, if that is the case, then it can be severed.
Thank you, Mr. Delanis.
This is discussion and action. Yes, Commissioner Starling.
I'm somewhat, I understand what Commissioner Delanis is saying, but if we get into changing the petition itself and the intent what the voters sign, do we have the legal obligation to do that? Because you're actually changing what 20,000 signatures said.
The thing that's different about the bond provision is that we would be acting on the number of signatures. Under the state law, that provision needed 10% not of the people that voted in the last general election, but 10% of the entire voter base. So we would have needed 40,000 or so signatures, or maybe more, on that part of the ballot. And we wouldn't be changing anything they wrote. We would be taking something out, though. So, I mean, there is certainly something to that, the idea of putting them all on there. I just suggest that since part of our ministerial duties is to look at the number of signatures, and this doesn't have enough signatures to change a provision that affects how Metro issues its bonds, that's within our authority. That's why I think it's different than just reaching down and changing the language.
I think Director Cooper has a word.
Yes, I just would like to point out that even if this petition did have, was signed by 10% of the entire eligible voting population of Davidson County, it still would not comply with the state law, which requires that petitions be specific to the specific bond issue being challenged and would not allow a general amendment of the charter that would put all bond issuances of $15 million on a specific project, make those subject to a referendum. So the number of signatures is not the only defect with the petition in this case.
I don't quarrel with that at all, but I'm just saying that the signature issue is something that this body, I believe, can address. The other issues, I don't believe that we can address those.
Commissioner Neal?
General Cooper, just to confirm, you agree with the point that Mr. Delanis makes with regard to the signatures on the bond issue, that in and of itself, the number of signatures is a deficiency as to form on its face?
I agree that the lack of that the number of signatures is a deficiency, is one of a number of deficiencies in form with regard to that provision and the amendment in general.
And with regard to the application of the elision concept, do we have anything that is binding or even narrowly on point with regard to referendum and the application of that concept, or would a court have weighed in on that yet?
We have not found any decisions in Tennessee that deal with that, which is probably because Tennessee does not make extensive use of the referendum process. But in states where there are a significant number of referendums, many of those states will, are very reluctant, and in fact, I think will not sever a provision, and in fact would have held that if one provision is improper, then the referendum should not go forward because there would be no indication of intent that it would have been supported by the signers had it been written differently, that they have no way of knowing what the signatories would have done when presented with a different document.
And so I guess it's fair to say that you would not find that there's clear authority for us to, in Tennessee, apply the elision concept to the referendum proposed against us?
I certainly would say there is no clear authority, and in fact would note that the doctrine is, as I said, generally frowned upon by the courts.
Thank you, General.
Thank you for that. That was very clarifying. I think also, as Mr. Roberts points out, back in 2008, when there was a referendum petition by Mr. Crafton at the time, there was an issue with potentially changing the language of the referendum. Things had gone back and forth, and this commission, I think, was tangled in this situation, or a somewhat similar one, on the idea of changing the language of a petition, and that did not go well for the commission on that particular issue. I, for one, would be very, very reluctant to tinker with the language of any petition, just knowing that that's what, the voters have voted for. That's the language that they've put down and the language that they've signed. It would make me uncomfortable to try to figure out what the voters' intent is, and to be able to pick and choose what provisions I think are appropriate or not based on the law. My strong preference, and I know we're not quite at a vote yet, but just to kind of let y'all know where I'm at, is if we do believe that there are some form problems with this petition, which I do, and I think probably the rest of us think there's at least some, or at least one, perhaps Mr. Roberts could redraft the petition, maybe with the help and advice of some others as to form, recirculate it, and let the voters try to do it in a way that, we find there is not a form problem. And that's kind of where my thought is at this point.
I can just say where I'm thinking of this is that it seems to me to be clear there's at least a deficiency as to form on its face as proposed. The open question in my mind is what does that mean with regard to the application of the Elysian concept? And it seems to me in terms of applying Supreme Court precedent, recent or otherwise, a court may be well suited to make a determination on the Elysian and otherwise provide some declaratory direction and judgment with regard to next steps, is where I'm right now.
Others, Commissioner?
And if I could also point out, I do think it was helpful that Mr. Roberts did tell us in the beginning, I believe you did say you were the one who drafted it or had been involved in drafting it, that it was meant to be one uniform piece that was submitted to the voters uniformly. It said amendment, not amendments, and that this was intended to be one piece and not 5 different pieces put together. So that was a very clarifying statement that has helped inform my opinion. I appreciate your information on that.
Commissioner Starling, did you have something?
Yes, I'm like Commissioner Neal. It seems like to me there's a whole lot of legality involved in all this, and we may need an opinion from the courts or so, because I'm not really sure where some of these things are going. And I think I would like to have a court opinion. I think that's kind of where I'm leading to.
Commissioner Delanis.
Yes. Let me just note that while I celebrate Mr. Roberts and his opinion, it's irrelevant to our consideration. He's maybe one out of the 20,000 people that signed this, and his opinion really should have no bearing on this. His legal arguments, perhaps, but not his opinion. We've got to deal with, just like looking at any other legal document, look at what we've been presented with, and there's a substantial basis to think that based on that document, these are separable, and under the existing Tennessee law and statute, at least as to statutory construction, that we can elide that one provision. But if given the choice of approving all of it, not approving any of it, I definitely believe we need to go forward today. We need to, if the other commissioners are uncomfortable with making any changes to it, then I think we just ought to put it all on the ballot. Speed is of the essence. We've got a timetable here from our administrator. That's the quickest way to get this before the courts. Even if we file a declaratory judgment action, we've got to decide what we want to present to the court. We've got to decide what we want to propose to the court. And we've got to tell our lawyers that. And Metro Legal may decide they don't want to represent us in that case. They may be suing us. So I think we have to make a decision, because at some point the court's going to turn to us and they're going to say, well, commissioners, what's your position? And we know what Metro Legal's position is, and it may not be the same as ours, and that puts them in a conflict situation. So, I am uncomfortable at this point also with the appearance of our suing a citizen group that filed a referendum, and I think we should try to avoid that if possible. It's just, I know among us lawyers, there's some lawyers here in the room, and there's some lawyers on this commission. A declaratory judgment action is thought to be a relatively mild thing, but we still would be suing a citizen group who brought a referendum before us, and I'm troubled by that. So I believe the quickest way to get this forward, and speed is of the essence, A declaratory judgment action, I've thought about it. It's, it has a lot of merit. We've talked about doing that in other instances, and there is a lot that is attractive about it, but it would slow the process down somewhat. We would still have to tell our lawyers what to do, and as you can see, we're having a little difficulty making an exact decision. I suggest we make a decision today, and still, one thing that really bothers me is that if we filed a declaratory judgment action, the for good government folks would be a defendant, and we would have to sue them. We could probably maybe sue other people, but we would have to sue them, and I'm uncomfortable with doing that. So I suggest that if we can get 3 of us to agree to put it all on the ballot, that we should. If we can't get 3 people to sever the bond provision, I'll be happy to go along with the majority that puts it all on the ballot.
Thank you, sir. Commissioner Hirschfeld.
I agree with Commissioner Delanis on a few points, and I do think the declaratory judgment element is very appealing in that, it can get us in front of a court and get a court to help us kind of wade through some of these thorny issues. But I do agree that I'm also concerned about this commission having to sue a group that has put forward a petition. I don't like that. I don't think government should be suing its citizens. It just doesn't feel good, especially when y'all are trying to participate in the process, and we should be encouraging that. So I'm with Commissioner Delanis that from a legal perspective, I do think it's a prospect that is good and enticing, but the mechanics of it do make it a bit more difficult. I also agree with Commissioner Delanis that I do think it would slow things down at this point, and I do think that time is of the essence to get this situation figured out for the people of Davidson County, so we can all kind of get some finality and move forward. However, based on the concerns that I've raised thus far, I won't be for putting the entire petition on the ballot or for severing.
Director Cooper, can you talk for just a moment around the issue of the declaratory judgment and exactly, in addressing Commissioner Delanis's concerns, who exactly we might be suing in this instance?
The template, the case that is closest to this is the Cummings versus Beeler case, which was a 1949 Tennessee Supreme Court case. It involved the Secretary of State bringing a lawsuit over whether the Secretary of State, in whose office is the state election coordinator, was compelled to hold a statewide referendum on an issue the constitutionality of which had been challenged. It was putting to the voters whether to call a limited constitutional convention, and there was significant dispute over whether the state constitution allowed for a limited constitutional convention. So the Secretary of State brought the lawsuit against the state attorney general and the state comptroller, that being the party who had raised the issue of the unconstitutionality of the referendum and the party who would pay for the referendum, that is the comptroller. So that was, there were some other ancillary parties, but those were the primary parties to the litigation. The analogous situation here, if the commission decided to go this route, would, as Commissioner Delanis points out, could involve suing metro government officials, the mayor, the finance director. If the other case involved the attorney general, perhaps the director of law. I would think that also you would want to include in the lawsuit the party that drafted the petition and circulated it. So that would be the For Good Government group. And then you would have all the interested parties with an interest in this in front of the court. And at that point, I think the commission would come forward and say that we understand our duty with regard to petitions to put them on the ballot, but there are some serious legal and form and facial validity issues that have been raised. With the Cummings case, the Secretary of State had gone to the court and said it would cost a lot of money to hold a statewide referendum, and we don't want to do that if it turns out that it was an unnecessary expense, since the referendum should never have been held in the first place. Presumably the commission would be going to the court to say the same thing, that we have this duty, but we understand that we also have discretion, and we don't want to engage in the expense of almost $1 million for a referendum that will ultimately be held not to have any effect. So that would be, I think, based on the precedent, how the commission might go about this.
Thank you. Thank you for that additional clarification and context. Mr. Neal.
I had a follow-up question as well. In terms of as a commission, our duty to move forward today with a specific affirmative kind of action plan, is it permissible? Is there authority for us if, for example, I concluded there was a deficiency as to form on its face, given the kind of binding case law that's available, would it be consistent with our ministerial duties and our discretion to then conclude that it should be placed before the people on a referendum ballot?
I would say that, kind of as we discussed in walking through the three options, if the commission decided that this should be placed on the ballot because either it lacks the authority to review these deficiencies, or it determines that the deficiencies are not sufficient to warrant taking it off the ballot, then that is one option available to the commission.
But in terms of reaching a conclusion that we do have the authority to make a determination as to form, and then deciding to place it on the ballot, is there clear guidance? And I don't know if you have any. It's somewhat academic, but also is kind of before us here, which is some of the colleagues have said that there's a deficiency, for example, as to signatures, but one option available could be that we place it on the ballot regardless. That may be preferable to other scenarios, and I just wanted to know if that was consistent with kind of our ministerial obligations and our oath and whatnot.
The courts, the Supreme Court has said that you do have the authority to review the form of the petition and the referendum subject matter, and I think within that discretion is your authority to make that decision one way or the other. Of course, that would be subject to judicial review, but it is your decision to make in the initial instance.
And last question. I used to be a litigator, but I'm not anymore. And the concept of interested parties and making a determination of who should be a defendant, the scope, the terrain of what serves as the basis for naming a defendant, it's not the I should ask, is it the ordinary concept of we have opposite positions and therefore I'm suing you to reach a resolution, or is it the subject matter such that there's interested parties that should be joined to the litigation and you join them as a defendant in that action? Making a determination on who should be the defendant. For example, in this case, naming as a defendant the good government organization, does that necessarily mean that our position in each way is adverse to theirs in terms of?
No. I think that all you are doing there by including them in such a lawsuit is acknowledging that they do have a justiciable interest in the outcome of the litigation. You would not be sending a signal at all as to either advocating for or opposing the position that they take or the other parties take. Basically, you're setting up a lawsuit where the interested parties can go to the court, make their argument, and you are provided with the guidance that you need.
Thank you, General.
I know all the commissioners are working hard to get this right. It's a pivotal time for our city and our county, and having a robust discussion to get us to a conclusion for our city and for our taxpayers, whom we have heard from today and in other fashions as well. Is there any consideration of a motion at this juncture? We do need to take an action.
It may be, this is just to get the ball rolling, but I would renew my suggestion motion that I've described a couple of times, if the chair would like me to do it again, but it would be the proposal to go forward to take out the preamble, as I would describe it, which is the lead-in 2 paragraphs, to take out the boldface argumentative language in the five sections, and to sever the section concerning bonds, and to put the remaining language on the ballot. I am offering that as a formal motion.
As a motion. Mr. Delantis has offered his motion. Do we have a second? Hearing none, I think that motion is dead.
Oh,
Yes,
it
sorry.
fails for a second.
Fails for a second. Thank you. I was trying to come up with the words and they weren't there. Thank you. It fails for a second. Let me be more appropriate. Thank you, sir. And again, thank you for the good thought and research you have put into all of this. Mr. Neal.
Now that the ball is rolling, I'll offer a motion in order to avoid the needless cost of holding an election on an invalid amendment. I would like to ask the court for a declaration that Section 19.01 compels us to put the amendment on the ballot, and for our counsel to name the interested parties in that matter.
A motion from Mr. Neal. Do we have a second?
Could you repeat the motion, please?
Sure. My motion is that we proceed with option 3 outlined by counsel, that we seek a declaratory judgment that Section 19.01 compels us to place the proposed referendum language on the ballot, and for our counsel to name interested parties in that litigation.
I second.
Thank you, Commissioner Starling. Any discussion?
Yes.
Oh, I'm sorry.
Yes, please. If we're permitted discussion, Again, while this certainly has some beneficial effects, and we've considered doing this before, we still have to give our lawyers direction. And if we are not sure what direction to give our lawyers, then there's going to be a period of time in which perhaps we try to make up our mind and perhaps have to hire new lawyers. And all that's occurring when speed is of the essence. We've got deadlines to meet that our staff are having to address. We still would have to, in my opinion, we've got to file a declaratory judgment action. A defendant would have to be the citizens group, and we can draft the declaratory judgment however we like, but it's still going to be the case that we're going to be suing a citizens group that's brought a petition before us. So that's why, even though perhaps in a different case, a declaratory judgment action would be the way to go, but that's my reason why I can't go along with it in this particular case.
Thank you for your candor. Commissioner Hirschfeld?
I just have a couple questions, I guess, statements. There's a form in my packet that has some key dates for the referendum election, and I'm not sure if the public is aware of them, so I thought maybe we could go over them just a little bit. So I believe the date on the petition to hold the referendum election would be December 5th, which is a Saturday, and that's the date that has been named within the petition. To have the date, to have the election on December 5th as requested per the election, we have information here from our staff and our administrator indicating that we would have to make a decision for setting the referendum election by September 30th. Is that correct, Mr. Roberts?
That's correct.
Okay, and today is September 25th, so that would be 5 days from now.
Correct.
Okay, and that, just so the public understands, would be because before we have an election on anything, whether it be a referendum or for somebody running for an office, there's a bunch of things that are tied to that date, which would be having the ballots approved and printed and sent out for absentee, early voting times, but most importantly, getting those ballots sent to our overseas voters and military personnel in order to be ensured that they can also participate in an election. And that is really the trigger for our earliest date. Is that right?
That's correct. That's a challenge for us to make all of these parts come together in time to have those ballots to the military on the 31st.
Okay. And my understanding is, from my own analysis, because, you know, lucky us to have so many lawyers on a commission, is that there is probably also a tad bit of flexibility for us to be able to move that date within a week or so of the requested December 5th. And if we were to do that, that might give us another week or so, perhaps two, to make some decisions regarding
December 5th date, that being on a Saturday, that's a little out of character for our voting public. They've never experienced a Saturday election before. So we would have to, that would be a big educational part on our schedule. In addition to that, half of our polling places are in private facilities, mostly churches. Looks like we'll be going to phase 3. October 1st, many more churches will be having services on Sunday. Puts us in a difficult position of guaranteeing that we can have a polling place in their house of worship the day before they prepare for services the next day.
Plus, a bunch of churches have Sunday school and various other things that happen on Saturdays. I know a lot of churches have Saturday services, so I can understand why that could be complicating. Okay. And so I guess that is all to bring back my point that I think Commissioner Delanis is right, that time truly really is of the essence here for us to make a decision on what to do. If we were to have to file a declaratory judgment action, which as I think you all know, have been a proponent of in the past, I believe we would have to sue Metro government, which I do believe is going to put us at odds with our Metro legal department, who's been representing us so incredibly well. I do have to echo that. It's been incredible legal representation thus far, and I'm very appreciative. But we would have to, at that point, then hire a lawyer, get that lawyer up to speed, get the lawsuit prepared to be filed. And I do share some concerns with Commissioner Delanis about that taking up, more than a few days in order for us to do that. Does anyone have perhaps a private lawyer lined up and ready to go that, we could shorten that time?
We do not have a private lawyer lined up, as you say, obviously, because that is a decision that would have to be made by the commission. We did, of course, receive an independent evaluation from Bill Koch, the dean of the Nashville School of Law. I spoke with him this morning to ascertain his interest in serving as counsel should we file a declaratory judgment or have other needs, obviously depending on our decision. He expressed an interest in being of assistance to the commission. He did note, however, and let me get my words right here, see if I can find my notes. He did note, to everyone's point, that there is a significant front-end loading on this work. And obviously, he has other time and commitment restraints. What he would recommend is that in addition to him, we would retain another firm or lawyer to provide additional support and research services. And it's my understanding that if we made the decision to hire him or any other names the commission chooses to bring forward, we could also authorize him or any other lawyer to engage additional counsel to provide assistance in that regard. That's the only conversation I've had.
I think that is very wise legal counsel from Justice Koch, and I think you can see that we're all struggling here for a variety of reasons, speed being the primary one. I think everyone wants to get this resolved and do right by the citizens who have signed the petition, but also to be sure that we're putting something in front of the public that is legal and supposed to be there. So I appreciate that information.
No, and I would be remiss if I did not add that Justice Koch asked me to specifically share that obviously his last name is Koch, but he wanted the clarity that he is not related to the Koch brothers, obviously the founders of Americans for Prosperity. So just so the record is clear. We have a motion and a second regarding filing a declaratory judgment. Yes, sir.
Just a point of order.
Please.
Just wanted to make it clear for the record that Justice Koch was retained by the Metro Legal Office to provide an independent second opinion to this board. This was not an action that went through the board, so the board took no action to hire a lawyer. This was a decision made by Metro Legal under the circumstances of this, that it believed that the commission would benefit from having a second opinion from outside of Metro Legal, and on that basis asked Justice Koch to come in and provide that analysis.
Thank you for that further clarification. I appreciate that. Is there further discussion on the pending motion?
And just to be clear, when I said a lawyer lined up, I meant a lawyer, in anyone's minds that you would suggest as being our lawyer. I obviously didn't mean that we had made any sort of a decision.
Oh, exactly.
Because clearly we had not.
Yes.
Just to clarify that.
Thank you.
I I do wonder, I'm just going to kind of keep struggling through this because I'm a bit of an outward processor. If our deadline is September 30th, that is the deadline we have to make a decision, meaning the court has to make a decision in order to get all those balls rolling, or what does that mean?
I think we would follow the guidance of this commission. Even if we don't have a final decision, we can start some of the pieces, put those in place so that we can begin moving along to be prepared for whichever way the court may go.
And we need to discuss this as well. We may be a little bit ahead of ourselves, but it's perfectly appropriate here in the context of this conversation. Whatever we decide, we likely need to set a conditional date on which the referendum would be held. General Cooper, can you address that for us, just with this September 30 notion looming? And should we put a conditional date, obviously, in anything we file in terms of a declaratory judgment?
I think it would be prudent for the commission to consider a conditional date. That would be a date that the commission adopts if a court in a declaratory judgment determines that the amendment is appropriate to go on the ballot. Obviously, this would only, you would do this only if the commission determines that it does want to pursue a declaratory judgment. Should it go with option 1, which is proceeding with the referendum, then you would just go ahead and set a date. Should it go with option 2, which is deciding not to put it on the ballot, then there is no need to set a date for this referendum. It's just on number 3, and it would not make sense to set a hard date, but you could set a conditional date so that you would not have to come back, and that would provide, as I understand Mr. Roberts, with the information necessary to do the internal work to be ready to proceed promptly and efficiently should the court determine that the matter should be on the ballot. But I would say that it would not, as I understand it, have any kind of outward-facing effect in that there would not be notices that would go out to voters or anything that would create confusion in the public that there was an election that had been set.
Thank you. Commissioner?
So I just want to kind of be clear on the two options that I think we now have before us, and just kind of lay all that out. We have about 5 days, maybe a little bit more, a little bit of wiggle room, kind of depending, to make a decision on whether this petition were to be on the ballot or not. If we were to determine that it should not be on the ballot, my great assumption is that we would be sued by the petitioners. It would get to court in that manner. Hopefully the court would take it up on an expedited basis. Metro Legal could continue to defend us if it was appropriate, and the case would move on, hopefully in an expedited manner, to the appellate courts and the way election challenges do, and hopefully we'd have an answer in time to make an appropriate decision for whatever deadline is set. That's option 1. Option 2 is that if we were to file a declaratory judgment action, this commission would have to meet again at least once to determine who to hire. We would have to then meet again with our lawyers to determine exactly what we want that lawsuit to look like and which defendants would be involved. And it's possible that suing a citizens group would be included in that, though I think all of us would find that to be undesirable, but perhaps necessary thing to do. Those lawyers would then need to get spun up in time, do the research, put together the appropriate things, listen to this meeting, have the transcript, do the variety of things you have to do in order to file a lawsuit, get the lawsuit filed, serve the other sides. Would be adverse to Metro Legal at that point and to a citizen group, and the court would still be making a determination of whether this is appropriate for the ballot. Have I summarized that correctly, Commissioner Cooper? Or General Cooper, Director Cooper?
I think as a general proposition, that makes sense. There might be some tweaking that could be done to that, but obviously you want to make sure that any actions that you take are taken in a public meeting with appropriate notice.
Okay, thank you for that. So I know we're getting ready to vote on that, but given those kind of two scenarios, the prospect of slowing the process down, as Commissioner Delanis had pointed out, and the prospect of suing a citizen group that has brought a petition, I think, perhaps before I might have found the declaratory judgment action option to be enticing for a variety of reasons, and I appreciate it because I think I've brought it up before myself, but I think I will likely not be supporting that and will be supporting just moving forward without the petition on the ballot.
And I'll just, if I could.
Oh, please.
Madam Chair, one item I'd note, if I don't relish the idea of naming as a defendant a civic involved group. I also don't relish striking in whole a proposed referendum signed by 20,000 plus based on my view of what is form and what is not. I think it's there, while there is some logistical headache that we as commissioners might have to juggle in order to take the approach to get the judiciary guidance, I do think on balance it's the wisest approach given the accountability of the system that we're in versus the judiciary and the judge's position with regard to the applicability of state law. And it's I don't think anybody's choosing their ideal scenario. We're, I think, trying to figure out what honors the will of the people and also accomplishes the logistical kind of ministerial and otherwise duties that we've got. It's a balance, and my proposal is one of probably several. So I'll leave it at that.
And let me just add to Commissioner Hersfeld's comments, and thank you, Commissioner Neal. We could certainly, as part of today's action, and potentially save one meeting if, depending on the result of this conversation, the commission is ready to act on looking at names, whether it's Justice Koch or others, but making a hiring decision today. Again, a potential time saver if there's readiness. We have a motion and a second. Is there any further discussion? Commissioner Neal, could you repeat your motion for us, please?
My motion is, in order to avoid the cost of holding an election on an invalid amendment, I propose that we seek declaratory action on an expedited basis from Chancery Court that has jurisdiction, and name all interested parties as defendants and seek guidance from the court with regard to whether the amendment, we have a duty to place it on the ballot.
You're ready to call the question? Ms. Harrison, would you call the roll, please? Thank you.
Negative.
Commissioner Neal, how do you vote?
Yes.
Commissioner Hersfeld, how do you vote?
No.
Commissioner Starling, how do you vote?
Yes.
Chairman Reynolds, how do you vote?
Yes. Motion passes. Director Cooper, what are our next steps? And do we need to further discuss setting a conditional referendum election date as well?
I would think that there seem to be two follow-up issues on the table here. One is conditional election date for this referendum. The second would be if the commission does want to go ahead and consider hiring counsel to prepare this and file this action. So I would say those are the two related questions to this motion.
Thank you, sir. Want to go ahead, since we've already touched on it, and go back to this referendum date discussion? So we currently have the date of December 5 as the referendum election date. Jeff, you've spoken a little bit to the issues regarding the difficulty, or the challenge, I should say, to that date. Is there anything further you'd like to add?
I think having the commission members recognize the challenges, especially for this particular presidential election, the possibility of contested issues. We have a lot of absentee ballots already. I think it's wise, and we would recommend and hope that you would give us sufficient time that we can put the presidential election to bed before we have to turn around and put all of our energy into putting another election on for this important issue.
You have suggested to us, and this is based on the Tennessee Code, we can set an election date that is not earlier than November 30 and no later than December 15. And do you have a recommendation for us to consider?
Yes, we would recommend to the commission December the 15th as the date. That would be a Tuesday. That is our normal election date for this type of election. The public would be knowledgeable of the election. It would be more likely that we would have all of our 160 precincts participate, so that if I'm normally go to the church around the block, that's where I would go to vote for this particular election.
And I just want to be clear, does this September 30 date then, is the deadline still apply if the commission chooses to set a conditional date of December 15 as opposed to December 5?
The September 30 date is when we would, based on action today, we would start putting things in motion. So if you set a conditional date of December the 15th, we would be working toward that date. Knowing that date now makes it more likely we will have a successful election on a referendum.
Questions for Administrator Roberts?
And keeping the date on December 15th, which is a Tuesday, that would be keeping with our traditional voting dates in Davidson County, which is holding our elections on Tuesdays and Thursdays, which the public has become somewhat accustomed to, as have our polling locations and early voting locations. Is that correct?
That's correct.
Thank you.
I believe if this is of interest to the commission in terms of setting a conditional referendum election date as recommended by Administrator Roberts, we will need a motion to that effect.
I'll make a motion to conditionally set the referendum election for Tuesday, December 15th, 2020.
Thank you, Commissioner Hersfeld. Do we have a second?
I'll second.
Thank you, Commissioner Neal and Commissioner Delanis. Is there any further discussion? Hearing none, Ms. Harrison, would you once again call the roll for us on setting a conditional referendum election date on Tuesday, December 15, 2020?
In favor?
Commissioner Neal, how do you vote?
Yes.
Commissioner Hersfeld, how do you vote?
Yes.
Commissioner Starling, how do you vote?
Yes.
Chairman Reynolds, how do you vote?
Yes, thank you. And now let's return to the discussion of hiring outside counsel as we pursue the filing on an expedited basis of a declaratory judgment. Commissioner Hersfeld.
I make a motion to hire Justice Koch.
Would you include in that motion the authorization for him to seek additional lawyers and/or firm for support and research?
Absolutely. I think he'll probably need it, yes.
Okay, thank you. Do we have a second?
I'll second.
Thank you, Commissioner Neal. Discussion, Commissioner Delanis?
Yeah, I have a clarification.
Sure.
Will we request Justice Koch to come back to us with his suggestions, or are we going to give him unlimited authority to hire whoever he wants as his second chair?
That's an excellent question. Go ahead, and then I'll that's an excellent question, and I appreciate you asking it because he assured me this morning he did not want to take that action. He did not want to take that action unilaterally, and would want to consult with the commissioners as he moves forward with those recommendations.
Okay. All right. Thank you. That clarifies it for me. So.
Great question. Thank you. Any further discussion or questions? Are we ready? Ms. Harrison?
Commissioner Delanis, how do you vote?
In favor?
Commissioner Neal, how do you vote?
Yes.
Commissioner Hurstfield, how do you vote?
Yes.
Commissioner Starling, how do you vote?
Yes.
Chairman Reynolds, how do you vote?
Yes. Director Cooper, I think that concludes this portion of the commission meeting unless I am missing, oh no, it does not. I have to go to the next resolution. Sorry. So sorry.
Before we went to the next topic, I wanted to make one note for the record, and
Yes,
also with regard to Metro Legal. I do think to the extent that there is discretion at the Election Commission under case law on applying the Constitution, the state laws, the preamble, that to the extent that Metro Legal could work and collaborate with the Election Commission to develop guidance for community members, civic involvement, to winnow down open issues as to form, won't be able to address the universe of potential form deficiencies, but I think we could have a good document that would assist organizations who want to follow the referendum process to do so as easily as possible.
And Metro Legal would be delighted to work with the commission on that project.
Excellent. Thank you, Commissioner, for a very good suggestion. We now move to our third item of business, and that is discussion and action on the charter amendment referendum that is based on Council Substitute Resolution RS 2020-480. Mr. Roberts, would you once again kind of set us up in terms of the procedure that our office went through on this, please, sir?
Yes, ma'am. The clerk has forwarded to us her certification of the resolution from the council. It's included in your packet. There is no further action on behalf of the staff at the commission. It's before you at this point.
Thank you very much. And just as we did on the previous charter referendum, if there's no objection from the commission, we will ask Mr. Mendez to return to the podium for public comment. I don't think we had any others signed up for public comment on this particular resolution, but I am happy to be corrected on that if need be.
Thank you very much. And before I start, thank you for all your service. I know for a volunteer commission, this is quite a load today and always, so appreciate your service to Nashville. This substitute resolution where the council passed a ballot item for referendum was born of the same concerns that y'all have been discussing for the better part of a couple hours, and that the language in the other item is most generously awkward and confusing and unconventional, and as I mentioned before, creates multiple active conflicts in language. And what we passed in the council is a ballot item that would seek to resolve the inconsistencies and conflicts that would come to pass if the petition item were voted in by the people. As I was in the council, I'll be very blunt now, all the conflicts would be resolved in favor of the current language, not in favor of the petition language. And so the voters, while they're in the poll, would have an opportunity to choose whether they seek to continue to operate under the existing language or move to this draconian other language. Just another option for voters to have a choice. Unless there's questions, I know y'all have been at it a long time. I know you obviously have read all the materials. Obviously, you're up to speed on the troubling aspects of the petition language. And I think we satisfied what we need to pass it in the council. I guess the only other item to discuss is we had language in what we passed that made it clear we did not seek an election on our item alone. So for whatever reasons, the petition item doesn't end up on a ballot. We're not trying to make Metro spend $1 million on this. So based on what you've decided, I presume the thing to do would be to have some sort of motion to conditionally place it on the ballot if you have a ballot. But I'll leave that to you and your able counsel to discuss. So unless there's questions, that's it.
Any questions?
Thank you very much.
Thank you
and thanks
very
again
much.
for your
Thank
service.
Thank you.
Commissioner Hertzfeld, did you have?
No, I don't have any questions.
Okay. Any further direction from Director Cooper on this matter?
I'll make a motion to conditionally set the second referendum on the ballot for the election on December 15th, if an election is to occur on December 15th by operation of the first referendum.
Thank you. We have a motion. Do we have a second?
Well, may I comment just briefly for the public? And basically, this is not a vote on the merits of a amendment. It's just a vote on whether it's proper in form. So that's what we're voting on.
Thank you.
I'd second the motion.
Thank you, Commissioner Starling. Any further discussion? If not, Ms. Harrison, would you call the roll for us, please?
Commissioner Delantis, how do you vote?
In favor.
Commissioner Neal, how do you vote?
Yes.
Commissioner Hertzfeld, how do you vote?
Yes.
Commissioner Starling, how do you vote?
Yes.
Chairman Reynolds, how do you vote?
Yes, please. Motion passes. Thank you. We're not quite done. At this juncture, we will turn to our AOE for his report.
Thank you, Madam Chair. I'll be very brief today. We have, as far as the November election, we have 21,000 absentee ballot requests in the office as of yesterday afternoon. We have 3,100 ballots already returned in the mail. We started sending ballots out last Thursday, and we had ballots returned by the post office on Monday. So they are doing an exceptional job as far as moving ballots through the mail. This week was National Voter Registration Day. On Tuesday, we had 3,000 voter registrations come in just by online voter registration. So we will be busy the next few days getting all of those voters registered and ready for November. We've also been busy with the Davidson County voters responding to our need for poll workers. We've had, in the last 2 weeks, 800 individuals come to our office, complete the paperwork to become Metro employees on Election Day to help us out. That's a record that we haven't experienced before, and we are very appreciative of the voters of Davidson County recognizing our need and standing up for us. That's it.
Good report. Good report. And I know I can speak for all of my fellow commissioners to say thanks to you and the team. We know this has been quite a year, and it is not over yet. So thank you, and just keep everybody safe and well. And I know everyone's working hard. Commissioner Hertzfeld.
And I'll echo everything Chairman Reynolds said. You guys are really doing an amazing job. Every time I think not another challenge can come up, I get a telephone call that there's yet another challenge that the commission is tackling and tackling so well. So thank you so much to you and the staff. I do have one question that I'd just like to get a little bit of public clarification on, if it's okay. I know that there's been some comments in social media about some capitalizations of a particular of some candidates on the sample ballot, and if you could just clarify what your investigation found and that the problem is only on the sample ballot.
Right. It was a typographical error on our part. The commission itself wasn't involved. This is our folks in our office, that myself included. Our proofing job was not up to par. In the past, we had, or for August, we had capitalized all the candidates' names on the sample ballot, but because of the number of folks running for president, we had to change the font style just to get everyone in a single column. When we did that, we copied and pasted from the August ballot, and as a result, we left 2 names that were capitalized. We put out a public statement to all of the media in Davidson County. As soon as we recognized that, I made public statements to a number of them. There's also been a question of the order on the ballot. The order on the ballot, the folks at Davidson County, we don't have a choice there. That's defined in state law. So the order is set. In fact, we have to send the ballot to the state for them to approve it before we can print it. Keep in mind, this error was only on the sample ballot. The absentee ballots that we've been mailing out, all of those are correct. Every name is in upper and lower case. The ballot that you will see election day and early voting, it was correct. There was no issue there. So what you see when you actually go to vote will be everyone looking exactly the same.
Thank you so much for that clarification. I appreciate it. And also the education, that the order of the names, I think some folks expect that to be alphabetical, and they think that there's something wrong when they see it and it's not alphabetical. But I appreciate you educating all of us and the public that it goes according to state law, according to the party that's in power. Their name gets to go first. So I really appreciate your hard work and your very quick response on that issue, and having the faith and knowing that the ballots are correct and we're moving forward appropriately. Thank you so much.
Commissioners, our next item is to set the date and time for our next meeting, and with your permission, I'd like to propose that we be subject to the call of the chair. We will obviously be meeting sooner as opposed to later, so your flexibility in setting our next time together would be appreciated. Mr. Delanis.
In view of the exigency and the fact that we should give at least 48 hours advance notice, I am at least suggesting that we consider setting a meeting now, even if we have to cancel it, because we have to hire a lawyer like right away. And I know it usually works better to do it at the call of the chair, but we're all right here, and I'm hoping that we can set a meeting for Tuesday, which would give us the 48 hours, I think, and that between now and then we can search our minds about what lawyers we might suggest, and perhaps even call some of them up to see if they would be willing to serve. And then maybe, of course, we would want to have Justice Koch here, I would think, so it would be subject to his schedule. But I would just be afraid if we start, if we go home this evening and we don't have another date set, that we might delay a day or two, and we don't have a day or two. And I'm sorry, but
Well, and just as a point of clarification, you said we still need to hire a lawyer. I think we did.
Well, but he wants, right, but I think he wants our input into
Correct,
his
right.
second chair, I guess you could call it.
There you go. Okay.
Yes.
But Commissioner Hirschfeld and then Commissioner Neal.
I think that's actually a really great idea to set something so we have something already set up. I can make myself available just about any time next week. And I would, I would prefer it. I think if Justice Koch perhaps had some folks that he, would like to work with, I think we all can probably come up with some suggestions if he doesn't. But I'm happy to hear his recommendations on who we'd like to work with.
And can we properly, General Cooper, can we give names to the chair, or can we make suggestions to the chair for her to give them to Justice Koch, or do we have to mention them for the first time in a public meeting?
I think that the commission members can certainly talk to Mr. Roberts on an individual basis and provide him with information that he can send to your counsel. I would do that rather than go to your chair.
Okay, thank you.
Mr. Neal?
And that was a clarification question I had, that I'm not opposed to a meeting. I think it's a sound approach, but I also wanted to, if there was an open question as to how we confer, if Mr. Koch can contact us directly, or we contact directly with him, or if we work through Mr. Roberts, that there was appropriate means to communicate other than a called meeting, and it sounds like we do have that option.
I certainly think that each commission member has the ability to talk with counsel on a one-to-one basis. Y'all simply can't use that as a way to circumvent the deliberation requirements of the open meetings law. But if you have particular questions or concerns or suggestions you want to convey to counsel, you're certainly free to do that. I don't know that you need to go through Mr. Roberts, although that's certainly an efficient way of doing it, or at least of getting the conversation started.
Thank you.
All right, to Commissioner Delanis's point, does everyone want to look at Tuesday afternoon? Does that give us the 48
I think 48.
business?
Yeah, yes. Ms. Ecke is usually the one that holds us to that. 48 hours. Is Tuesday afternoon, would that satisfy the 48-hour rule?
Based on the circumstances, yes.
Okay.
This
All right.
adequate notice depends on the facts and circumstances. And
Okay.
the time is of the essence.
And can we get a notice out this evening? Okay. All right.
Or Tuesday morning? I mean, I don't know, I just said afternoon, but if Tuesday morning counts in the 48 hours, maybe that's better on everyone's schedules.
I'll make myself available all day.
Me too. I'd like it if we could have this room again.
Morning is better for me personally,
Okay,
but I
all
can
right.
make anything work.
9 a.m.?
Okay.
Jeff, can you do that? 9 a.m. Tuesday, and let's do place TBD while we check on availability. Okay. Great point, Jim. Thank you for urging us to move ahead. I believe this concludes our business for the day. Thanks to everyone for being here and for sharing your thoughts and passion with us. Again, it is a pivotal time for our city and for the taxpayers of this city, and I think you can tell from this commission's discussion, once again, as I said earlier, we want to get this right for Nashville. Commissioner Hersfeld.
Motion to adjourn.
Thank you very much. I was going to give it to you. Do we have a second?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information